The Federal High Court, Abuja, has fixed 11th of May for definite hearing in a suit involving Professor Anthony Adegbulugbe, a former special advisor on energy in the President Olusegun Obasanjo administration, and others. Justice Ijoma Ojukwu fixed the date after all pending motions relating to the substantive matters had been regularized by counsel to the parties. Adegbulugbe, the chairman, Green Energy International Limited, and two directors, Dr. Bunu Aligbe and Mr. Ayodele Olojede, have been locked in legal battle on the ownership and running of affairs of the oil company. The company is the plaintiff in the suit marked FHC ABJ CS 1390-2020 with Aligbe and Olojede as the first and second defendants respectively. At the resumed sitting, the two defendants, through their counsel, sought for an order of the court to discharge the ex parte order granted in favor of the plaintiff on November 4, 2020, which compelled them to attend an annual general meeting of the company slated for November 12, which they did not attend. The defendants, while arguing their motion seeking to discharge the order, averred that they did not attend the meeting because the notice ran foul of the Companies and Allied Matters Act (CAMA), which requires 21 days' notice before the meeting can be convened by the company. They told the court that the ex parte order infringed on their fundamental rights to freedom of association, adding that the order was obtained by the plaintiff by concealing material facts before the court. They urged the court to vacate the ex parte order against them in the interest of justice, but counsel of the plaintiff opposed the application on the grounds that the ex parte order complained against had no life again. He argued that the order was to last for 14 days and that the 14 days had since expired. In her ruling, Justice Ojukwu held that the ex parte order had become an academic exercise, adding that delving into it would amount to premature incursion into the substantive matter. The judge then fixed May 11 for definite hearing of the substantive matter. NAN reports that Adegbulugbe in the suit is praying the court for a declaration that the two directors, Aligbe and Olojede, with 22.6% shares, cannot impose their will on the majority shareholders who approved and sanctioned agreements reached with third-party entities for the benefit of the company. The complainant also wants the court to restrain the two directors from doing anything inimical to the interest of the firm, but use internal mechanism in resolving any dispute. However, in their counter-affidavit, the two directors claim that Adegbulugbe usurped the function of the managing director of the firm and had been taking unilateral decisions that were against the objectives of the company. The two defendants averred that the former Obasanjo aide had engaged in alleged infractions by involving multinational companies in the operations of the company without their input. Contrary to the claim of the chairman that the two directors have only 22.6% shares in the company, the defendants asserted that they are owners of 25% shares. They therefore prayed the court to protect them as executive directors and as bona fide minority shareholders of the company. NAN reports that the management crisis is said to be threatening the daily production of targeted 30,000 barrels of crude oil.